Okay, the mics are on. Good afternoon. I apologize for the slight delay, but the earlier sessions had gone over. And I'm Reginald Lowe, and I'd like to call to order the Enforcement Committee of the Medical Board of California. Renee, can we have the roll call, please?
Yes. Good afternoon.
Oh, Teresa is going to do it, I guess.
Hi. Dr. Gonadev?
Here.
Dr. Levine?
Here.
Mr. Serrano-Sewell?
Here.
Ms. Shipsky? Ms. Yaroslavsky? And Dr. Lowe?
Here.
We have a quorum.
Okay, maybe you can help round up the other two.
Okay, I know we're still in, well, I'll find. Yeah.
Can we do that?
Ms. Shipsky should go.
Okay, so we will now take public comment on items not listed on the agenda. Speaker slips are available in the back of the room. If you would like to speak, please hand it to either Teresa or Ms. Threadgill. For those who want to speak on items that are on the agenda, please go ahead and fill out the speaker slip, and you will be called after each specific agenda item is raised. Okay, so we have one public comment from Genevieve Carrul. So we're going to limit, oh, there's another one as well. So we're going to limit comments to 3 minutes. Okay.
Good afternoon, Medical Board. Genevieve Claverol. I want to bring an issue to your attention. On March 6th of this year, my daughter went to see someone who was identified themselves as a psychiatrist for an organization named Winston Behavioral Health. My daughter, who is 50 years old, was with that so-called physician for less than 15 minutes, was not given any test or whatever, was told that, have you ever been diagnosed as bipolar? And at which point my daughter told that individual, you know, my mother is an RN, and she was teaching psychiatric nursing. I think if I had bipolar, she would have identified me as so. At this point, that individual never said, you know, oh, I am also an RN. I think that would have been a good clue. At the end of the 15 minutes, she told my daughter, I think maybe you should be hospitalized, and prescribe her 2 drugs for, you know, bipolar, Lamictal and Celexa, never telling my daughter how to take those medications. When my daughter came back to see me in the lobby, and I read the prescription pad, this individual is not a physician. She's a nurse practitioner. You know, I have nothing against nurse practitioner, but I surely have something about misrepresentation. Specifically, when someone pretends to be a physician, label my daughter with less than 15 minutes at being bipolar, give her prescription who are pretty significant, and not give her a reason why she was going to have to take that medication and how should we take it. The name of that individual is Yvonne Estrada Bazan. I have already filed a complaint with the Board of Nursing as a misrepresentation of the facts. And I think she was practicing medicine without a license, and I would like some action being taken.
Okay, thank you for your comments. Okay, so we have another public comment from Alicia Cole.
Hi.
Good afternoon.
Good afternoon. Thank you for allowing me the opportunity to speak and to be here today. My name is Alicia Cole, and I am an activist and a survivor. I am with the California Safe Patient Project, which is a division of Consumers Union. We are the California Safe Patient Network, and I want to speak to you today about an issue that is not on the agenda today, but I feel that it is one of great importance for the public and for the safety of the citizens of California, and that is an issue related to posting malpractice settlements and judgments on the California Department of Public Health website. I myself, I'm a survivor of necrotizing fasciitis, commonly known to the public as flesh-eating disease. I acquired necrotizing fasciitis, sepsis, Pseudomonas, VRE, and MRSA during a routine procedure to have 2 uterine fibroids removed. I left the operating room with a fever, nausea, vomiting, and from there, my 2-day hospital stay turned into 2 months, a month in the ICU, 6 additional surgeries, almost having my left leg amputated, 5 months of everyday hyperbaric oxygen chamber treatments, a year and 2 months of twice-a-day home health care nursing, 3 years with an open, draining abdomen, and for the last 6 years, including now, I am still in physical therapy and pelvic floor rehabilitation. I have on a heating patch and a back brace as we speak to get through this meeting. The highlight of my hospital stay was having my doctor do a bedside procedure, cutting me open in my hospital bed without anesthesia, without wiping my stomach or cleaning it, and asking my mother to assist him when the nurse did not come back to the room. I've since learned that I was my doctor's 3rd encounter with necrotizing fasciitis, and he's had a patient with necrotizing fasciitis after me. If you look at the medical board's website, he has no settlements and no judgments against him. If you go to the Burbank courthouse, you will find that there are 8 cases against him. And I know of 2 personally that have settled for over $30,000. Now, according to the Business and Professional Code, Section 2001.1, the medical board's highest policy priority is to protect the public. One of the most important ways that we feel that the medical board can accurately protect the public is by displaying their malpractice judgments and settlements and disciplinary history. This allows the consumers of California to be better informed about the choices that they make when they're entrusting their life and their livelihood to a physician. A November 2008 report by the California Research Bureau to the medical board stated that disciplinary and citation histories of at least 10 years are useful for forecasting the likelihood of future disciplinary actions against a physician. And additionally, their research showed that malpractice payout histories and settlements reported to the medical board, whether or not these were disclosed to the public, are directly predictive of future disciplinary actions for 5 years and indirectly predictive for a longer period of time. And that is from a report that was received by the medical board in 2008.
Thank you for your comments. I think your time is up.
I thank you for your time, and I hope that you would please take that into consideration.
We appreciate your comments. Okay, are there any additional public comments not on, for things not on the agenda? Okay, with none, then we'll move on to the approval of the minutes from January 31st, 2013. Is there a motion to approve these minutes?
So moved.
Do we have a second?
Second.
We have a motion and a second. Is there any public comment, discussion? All those in favor of approving the minutes, please say aye.
Aye.
Any opposed? Abstentions? Minutes are approved. Okay, so we're going to take things in a slightly different sequence. We've been requested to change the order of the agenda items. We're going to take number 10. Is it number 10? Item number 10 next. And Item 10 is a discussion of the Medical Board of California's efforts to implement SB 1441, which is uniform standards. Can we have Ms. Katie up to make those comments? To give the presentation, please?
Thank you.
Okay, Ms. Katie, thank you.
Good afternoon, committee. For the benefit of some of the newer members of the board, I would like to start this discussion with some background on the uniform standards related to substance abusing licensees. SB 1441 required the establishment of a substance abuse coordination committee under the Department of Consumer Affairs, which consisted of executive officers from the healing arts boards. The committee was tasked with formulating uniform and specific standards in 16 identified areas that each healing arts board shall use in dealing with substance abusing physicians. The board began the process of updating the regulations containing the current model disciplinary guidelines in 2009, and the majority of the changes incorporated in this edition were discussed and vetted in 2009. During that same period of time, the Substance Abuse Coordination Committee started drafting the uniform standards. The first set of uniform standards was adopted by the committee in April 2010. In August, the board opted to withdraw the regulation package and start the rulemaking process again. A public hearing was held in November 2010 with the intent of moving forward with the updated disciplinary guidelines. In response to public comments raised at that meeting, the board scheduled an interested parties meeting in January 2011 to take public comment and consider any additional changes that might be needed. On January 28, 2011, the board voted to adopt the regulations containing the disciplinary guidelines after addressing issues raised at the interested parties meeting. The board's regulation package moved forward and was approved by the Office of Administrative Law in December 2011. Just a little more background on the Diversion Program. The Diversion Program was established as a monitoring program that allowed physicians impaired due to substance abuse a pathway to be diverted from disciplinary action. As part of the intake process, participants signed contracts with the board requiring that they adhere to conditions such as a clinical evaluation to identify an appropriate treatment program, and aftercare, which included individual group therapy sessions, AA meetings, worksite monitors, and random biological fluid testing. Staff in the Diversion Program were responsible for monitoring physicians to ensure that they were complying with the terms of their contract. In 2008, the board allowed the Diversion Program to be sunsetted because multiple audits had found that physicians with substance abuse issues were not being adequately monitored. The policy decision made by the board was that physicians would be solely responsible for their own treatment and recovery from substance abuse. Through the probation monitoring unit, the board would only monitor the physician's fitness for practice and compliance with the abstain from use requirements through the biological fluid testing. One of the major criticisms raised at the last meeting was the assertion that some of the uniform standards did not apply to the medical board because the board no longer had a diversion program. In retrospect, the use of the term not applicable was a poor choice of words. The Department of Consumer Affairs has sought several legal opinions on the issue of whether the use of uniform standards was discretionary. The legal opinions all indicate that healing arts boards must use the uniform standards when it undertakes an action covered by the standard. In other words, if the board orders a licensee to undergo a clinical diagnostic evaluation, the criteria set forth in Uniform Standard Number 1 must apply. When updating the disciplinary guidelines in 2011, staff focused on incorporating the requirements from the uniform standards into the conditions that the board would order for a physician with a substance abuse issue. Because the board does not order a physician to undergo a clinical diagnostic evaluation or enter into a treatment program or attend group support meetings, those standards were not addressed in the board's disciplinary guidelines. It's unclear whether the board could demonstrate to the Office of Administrative Law the necessity for standards relating to diversion program requirements in the absence of a diversion program. And we believe that maybe further legal analysis is required to answer that question. The main conditions that are ordered by the board for physicians with substance abuse issues are the requirements to abstain from the use of drugs and alcohol, biological fluid testing, a psychiatric evaluation and psychotherapy, and or medical treatment. I'd briefly like to review each of the standards that have been implemented by the board, either by incorporating the requirement into the disciplinary guidelines or through probation unit policy. Uniform Standard Number 3 identifies requirements that allow the licensing board to communicate with a licensee's employer about the licensee's status or condition. The probation unit currently requires the physicians to complete a quarterly declaration, which identifies the clinic name, the address, the work schedule for any locations that a physician practices in. Contact information for the medical director or chief of staff must also be provided. Employer information is also confirmed verbally during each quarterly interview with the physician. The probation unit can develop a release to be signed by the physician in order to allow them to communicate more freely with the employer as needed. Uniform Standard Number 4 identifies the requirements for all aspects of the required biological fluid testing, including testing frequency and the standards for testing locations. This uniform standard was controversial primarily because of the differing opinions and discussion related to the required testing frequency. The uniform standard initially proposed that all licensees be required to test 104 times per year during the first year of probation. The board's existing disciplinary guideline required that physicians be tested a minimum of 48 times per year, and the board's current guidelines do not identify specific testing frequency. The lack of specificity was by design in order to give the board greater flexibility in scheduling biological fluid testing as needed. In 2011, the board was involved in defending a writ of mandate filed by a physician who was challenging the testing frequency that was contained in his disciplinary order. Testing frequency was discussed at the hearing in January 2011, and Ms. Whitney noted that there was no agreement on this issue amongst the substance abuse committee members because there was no evidence-based information to support requiring 104 tests per year. The committee was scheduled to revisit this issue, but over a year had passed without it being addressed. So MBC went forward with the proposed language that did not contain a specific testing frequency so that the testing frequency could be established by policy once the uniform standard was finalized by the committee. In April 2011, the committee revised the uniform standard to the current testing frequency of 52 times to 104 times per year during the first year of monitoring. The probation unit uses this testing frequency as the standard for physicians with biological fluid testing requirements. Uniform Standard Number 4 also contains specific requirements for specimen collectors, collection sites, and response times for lab results. The probation unit has established a contract with First Lab to perform the biological fluid testing requirements contained in Uniform Standard Number 4. The requirements of the contract include all of the requirements that have been incorporated into Uniform Standard Number 4. It should also be noted that other healing arts boards also utilize a contracted vendor to perform biological fluid testing and fulfill the requirements of this uniform standard. Is that one 8? Okay. Uniform Standard Number 8 and 9 identifies procedures to be followed when a licensee tests positive for a banned substance. This uniform standard requires the board to issue a cease practice order, contact the licensee and advise them to leave work, and notify the employer that the licensee may not work. After notifications are made, then the board must determine whether the positive test was in fact evidence of prohibited use. If so, then Uniform Standard Number 9 applies and identifies the confirmed result as a major violation. The penalties for committing a major violation are then spelled out in Uniform Standard Number 10. The board updated the language in the disciplinary guidelines to allow the issuance of a cease practice order in order to conform to this standard. At the interested parties meeting, CMA expressed strong concern that imposing a cease practice order or an automatic suspension without affording the licensee due process could be considered unconstitutional and may violate the 14th Amendment. In response to this concern, the board added language to specify that an accusation must be filed within 15 days or a cease practice order would cease or would lapse. The amendment provided the licensees with a mechanism for due process, but still allowed the board to remove the physician from practice as the uniform standard required. Finally, Uniform Standard Number 10. Uniform Standard Number 10 identifies actions that the board will take for minor and major violations. It's the board's current policy to proceed with administrative action for any substantiated violation of the terms and conditions of probation, particularly those that relate to fitness for practice or failing to comply with an order for a medical or psychiatric evaluation or testing positive for a banned substance. At the time the regulations containing the disciplinary guidelines were being vetted through the rulemaking process, the uniform standards were still being discussed and finalized. We recognize that there are amendments that need to be made to the board's disciplinary guidelines in order to more fully incorporate the uniform standards. For example, the board does need to define a trigger which would identify a licensee as substance abusing in order to prompt the imposition of a mandatory conditions that are ordered under the uniform standards. The board also needs to provide direction to the ALJs and the AG's office that they have no ability to modify the relevant conditions in the uniform standards for physicians identified as substance abusing. There is still much discussion amongst the healing arts boards about how best to incorporate the uniform standards into regulation. There are 18 healing arts boards that are required to implement these uniform standards. The Department of Consumer Affairs has identified that only 4 boards have adopted the standards through regulation. The 4 boards that are identified as being in compliance are the Board of Occupational Therapy, the Optometry Board, Vocational Nurse, and the Respiratory Care Board. None of these boards have diversion programs. Only 1 board has incorporated verbatim all of the language from the uniform standards into regulation. The remaining boards have either modified the language or incorporated standards or have modified or not incorporated standards that were specific to diversion program requirements. The larger healing arts boards who have diversion programs, such as Board of Pharmacy, Dental Board, Veterinary Medicine, have not incorporated the standards into regulation or into their disciplinary guidelines. Staff is proposing that we return to this committee with some recommendations for any modifications needed to the disciplinary guidelines to implement components of DCA's uniform standards that have not previously been addressed. Question?
Okay, thank you for that very thorough discussion. Do we have comments from the board members? Yes, Mr. Sewell.
Dr. Lowe, thank you. So, very good presentation. Thank you. And I've in this issue and discussion. All right, there we go. I've had a chance to take another look at SB 1441, the legal opinions that are floating around, trying to grapple with what may be some outstanding legal issues. The board's actions, most recently at the last enforcement meeting, which I thought that this committee was pretty clear about what it wanted to do. So, I mean, at this stage, I'm of the mind that the board, through this committee, ought to adopt all the standards and begin the rulemaking process. And so, and it's through that rulemaking notice and comment period that we can fashion the regulations, assign them to the right parts of our jurisdiction and just sort of move on. This has just, in my mind, been an ongoing issue. I think the best thing to do is to adopt the remaining standards that we have not adopted, recognizing, as your report notes, that it does present some challenges. But that's either here nor there. I mean, we'll deal with it. As to what other healing arts boards and commissions do, that's up to them. You know, I'm on the medical board, so I'm concerned about what we do. And I just have a very strong desire to just bring closure to this issue, not prolonging it any further. And the first thing to do is, in my mind, to answer your question, or a question that you raised in the report, how do we implement it? Well, by adopting them and then commencing the rulemaking process. And we'll see where that leads us. And I'd rather, it's my preference to go on record as soon as possible as a full board, adopting all the standards, all of them, and leaving no ambiguity about what this committee or this board feels about any one particular standard. I personally don't think, and people can have a different opinion, and I know it's very complex, I don't think a diversion program is a condition precedent to adopting some of those standards. I don't. Reasonable minds might differ. I don't think it's a condition precedent. I think the legislature's and the governor's intent is pretty clear in my mind that we adopt the standards. So that's where I'm at right now.
Thank you. Are there other comments, Dr. Levine?
Yeah, as I've spent time thinking about this over the last few weeks, it's occurred to me that one of the potential disconnects is that standards are different than guidelines. Standards don't leave you, guidelines leave you the ability, give you the ability to adjust based on the facts and circumstances of a given situation.
Right.
And I think to some extent what we have done is said, well, we address this in the disciplinary guidelines, so de facto, we have adopted the standard. And we can't do that and at the same time say, yeah, but when we deviate from the disciplinary guidelines, it's based on judgment that in the facts and circumstances of the case, the guideline is only a guideline, and so we have the flexibility to adjust it. And I think to some extent we're caught in that. One is a standard doesn't give you the option of deviating, whereas a guideline says this is to provide guidance. We rely on you as professionals, as members, public and professional members of the board, to use your best judgment given facts and circumstances. So I think that's sort of where we've gotten hung up to some extent, is we've looked at it and said the words are there, but they're in different different frameworks, and they're not identical.
Okay, thank you. Are there other comments? Dr. Guanadev.
Thank you. I have the same problem as Dr. Levine, is that medicine is science. It's not just a standard you apply. It's a guideline is a lot easier way of dealing with a unique circumstance. And one other issue I have is that we deal with drug testing quite often, and a lot of urine tests are screening tests. So they're not the confirmatory test. Then there is a confirmation you have to do, because you do get false positives. So that's why we want to make sure that we do it right scientifically, at the same time follow the law. I mean, that is, we understand that in the end we are employed by the government here. We do need to follow the law. So I think we need to come up with how do we marry those issues. Maybe like Mr. Serrano so well mentioned, that maybe adopt the standards and then start the rulemaking process and take care of those concerns I have in the rulemaking process. So that way, then you still dealt with the scientific part. We are scientists in the end. I mean, that's what I went to medical school for. So to really put the science back in and really do appropriately.
Ms. Shipsky?
I have to agree with David. I think we need to move forward, get these adopted, and then we can work out as the rulemaking process goes forward. It's very clear in the materials that we've been given that the intent of this bill is not to dictate specifics, but to set parameters. And I think that we need those parameters. It's been many years since this diversion program was taken out of the medical board.
Right.
It's an ongoing problem, and I think the sooner we can start on that rulemaking process, the more clarification we can get. One of the things I need to ask staff that I didn't see in here, is there any standard regarding probation? Because we're often faced with someone who has been a substance abuser who then is on probation, and there is really no set guideline that I have found that they often will come to us as a board and request that their probation be removed and that they can go back into practice. So is that something that any contemplation on a standard for probation?
The standard did not address specific required time frame to be monitored, if that's the question, if I'm understanding your question correctly.
Okay. I would hope that I would hope that we somehow grapple with that.
We can if we're going to open up the disciplinary guidelines again. There's a recommended penalty, so that might be the place to deal with that framework.
But I would agree with my colleague. I think we need to move forward and get going on the rulemaking process. And in that process, I think we'll be able to fine-tune specifics relevant to this board, which I think is the intent, again, of the law, is to set parameters, but certainly then to allow the different boards, if they need to fine-tune something within those parameters. But we need to move on this.
Okay, appreciate your comments. We have 2 slips for public comment. I'd like to call on Alicia Cole, 3 minutes once again. We have a very long agenda today, so we need to be efficient.
Okay. All right, ready to go. Hi, again, I'm Alicia Cole, and I'm with the Consumers Union Safe Patient Project regarding the uniform standards. And I just want to thank you for supporting the adoption of the uniform standards and encouraging those of you who are may still be unsure. As you know, substance abusing physicians pose a significant risk to patients who typically are unaware of the problem. And when these issues come before the medical board, they should be addressed through a comprehensive and predictive process that the public has full confidence in, that is transparent and has integrity. And we've testified before to the medical board, various advocates, that, excuse me, we really see the urgency of this, and we want the full adoption of these standards. We urge you to adopt them completely and immediately. And as you know, the Legislative Counsel Bureau, the Office of the Attorney General, and the Department of Consumers Affairs has issued opinions unequivocally stating that these standards are mandatory and that they are to be used by the healing arts boards. And as you know, most recently, the chairs of the legislature's Business and Professional Committee, Senator Price and Assemblyman Gordon, in a letter threatening the very existence of the medical board, said that the medical board needs to adopt the uniform standards as required by SB 1441 in order to protect patients in California. Now, Section 1315C of the Business and Professional Code says that these uniform standards, and I quote, that each healing arts board shall use in dealing with substance abusing doctors whether or not a board chooses to have a formal diversion program. This is California state law now, and it is not within the discretion of the medical board to fail to implement these uniform standards. As you know, the medical board staff prepared a document for today's meeting relating to the board's implementation of these standards, and it is not within the medical board's discretion to pick and choose any of these possible standards. And as we stated in our testimony at the last board meeting, one of the other advocates, Tina Manassian, which was also distributed to you, and I have a copy of it here today if you would like. There are several important requirements in the uniform standard that are missing, as you know, and we want full adoption. So we ask you to come into complete compliance with the requirements of SB 1441 and that you implement them immediately. Thank you.
Thank you for your comments. On an initial public speaker is Julia DAngelo, Falmouth. So just to take the heat off of me, we have a timer here, so when the timer is 3 minutes, just turn off the mics, and I think they'll get it. That's what they do at major programs, so I think we should implement that here.
Music.
Okay, just turn off the mic at 3 minutes.
You're starting with me?
Yes, absolutely.
Not being
Okay,
pejorative, Ms. Falmouth.
okay, your time is starting.
Thank you, Dr. Lowe. Julie DAngelo, Falmouth from the Center for Public Interest Law. Dr. Levine has identified the problem. There is a huge difference between your disciplinary guidelines, which are discretionary, and the uniform standards concerning substance abusing licensees, which are not. They are mandatory, we know that. What you did was to incorporate some, but not all, of the uniform standards into your document that is called disciplinary guidelines. Then you amended your disciplinary guidelines regulation. That is the source of the problem here. That regulation is not quoted for you in these materials. I don't have it in front of me, but it says something to the following effect. In reaching a disciplinary decision, the board shall consider the guidelines and standards in the January 2012 version of its disciplinary guidelines, which is hereby incorporated by reference. Deviation from these guidelines and standards is permitted if the board, in its sole discretion, decides that deviation is appropriate. You can't use that regulatory language with the uniform standards. You have to separate the uniform standards out because they're not discretionary, as your disciplinary guidelines are. What you need to do is adopt a reg that says the following. In reaching a disciplinary decision involving a substance abusing licensee, the board shall comply with the uniform standards adopted by the Substance Abuse Coordination Committee in April of 2011, which are hereby incorporated by reference. That's what the other healing arts boards are finally doing. That is what you must do in order to fully implement and legally implement the uniform standards as required by law. Thank you.
Appreciate your
124.
comments and holding to the time. So if there are no additional public comments, I think that perhaps we should entertain a motion from this committee that we have the larger board adopt the uniform standards of SB 1441.
Yeah.
Okay, do I have a motion?
So I knew this meeting could not continue with me having to say something. So I want to be candid. Not on the merits of 1441 and its standards. I think that issue's been well discussed, well documented. I think the issue is from the legal perspective, Ms. Dobbs and myself, Ms. Webb, how do we get there? It would be my legal opinion that the board cannot just simply adopt the regulation, adopt the standards, and then move on with regulation. I believe the way you get to 1441's implementation is you adopt regulations that address the issue that incorporate the standards. The reason I say that there's a portion of the government code in the Administrative Procedure Act way back about 11.340.5 or something that says no statute, no guideline, no manual, no bulletin, no anything, no policy, no good idea, if you will, can be enforced unless it's gone through the full rulemaking process. So there's some tension there. So what I would suggest is the board may want to, this committee may want to consider recommending to the full board that it commence immediately the rulemaking process to essentially establish for the medical board the 1441 regulations 1441 standards in regulation. And by in regulation, as Ms. Falmouth pointed out, not in the guidelines section, but a standalone section that in fact would say, if in fact there is a disciplinary decision involving a substance abusing licensee, then the following shall apply. And that takes it out of the sort of deviations are warranted, like the 1361, sort of the enabling regulations for the disciplinary guidelines. This, in fact, would take it out of that discretionary rule of the board and put it more into a thou shall, the following shall apply. So I don't want to be the wet blanket. I don't want to be the most disrespected, disliked guy in the room, but I would respectfully suggest that the way you get to implementing 1441 standards would be to immediately recommend that it immediately commence to the board that it commence the 1440 rulemaking procedures, regular rulemaking procedures, and for the time so that the board may hear it at the next available opportunity.
And I'll briefly just add to that. The reason you can't get to there from here and simply just adopt the uniform standards is because we believe, and the legal opinions that we have suggest that they are not self-implementing. So if you simply adopt them and start using them, you're essentially doing an underground reg.
So what you're indicating then, that what we have to do is very similar to what was just suggested, that we indicate that they be incorporated by reference, correct? If we're dealing with this.
No, what we need to do is we need to commence the rulemaking process.
No, I understand that, but in those rules, at that point, language needs to be crafted that indicates that these, when dealing with a substance abuse physician, that these standards shall apply.
Yes.
Okay.
Yes.
I think that's where we were trying to head.
So really, it's just, we really support this 100%, but it's just the process by which we get there. And I don't think any of us are opposed to that, and I would entertain a motion that we do whatever Mr. Hepler suggested, so that we can get to that end.
Kurt said.
No, I want, as do I, and I'll make an attempt to summarize it or to restate it just for the record. But this is the benefit of having our in-house counsel, understanding our special restrictions, limitations of our authority, and giving us excellent legal advice so we can implement our policy objective within the confines of the law. So thank you. All right. So, and I think our intent's pretty clear, however we say it. So commence immediately the rulemaking process to implement SB 1441 standards in regulation. And there's a reporting aspect to it. Report back immediately to this board at its next available meeting, at its next meeting.
No, second that. Can I clarify?
Sure.
Do we have to in fact instruct that as part of this motion is that with the intent that these standards would be incorporated by reference? Or do we wait till the rulemaking? I just want to be real clear that we may go through the rulemaking process, but the intent obviously of the motion is to make certain that we do incorporate them.
Right. So let me just back up. Let me hit the brakes. I'll say two things. Number one, I think this committee's action would be a recommendation to the full board.
Yes.
Okay. Because I have people gesturing excessively. The second issue is, Ms. Shipsky, whenever we have a large document like this, we point to that in by incorporations by reference, so we don't have 45 pages of regulation. But I think it would be clear is that we would say, if in fact we have a substance abusing licensee, the following standards would apply as incorporated by reference.
And that would be, I think, where we were trying to go. So I would like that certainly very clear in our recommendation to the full board.
And the motion is for the recommendation to the full board. Thank you.
Dr. Levine, do you have a comment? Okay, I just love how these attorneys can talk to other attorneys.
Yeah, I know.
Okay, so we have a motion, and do we have a second? We have a second? Okay, any other public comment, discussion? Okay, so we'll call for a vote. All those in favor?
Aye.
Aye.
Aye. Opposed? Abstain? Motion carries. We'll make that recommendation to the full board. I appreciate your input, Mr. Epler. Okay, so now we can get back on track, and we will now deal with agenda item number 4. We have Ms. Laura Sweet here to give us a presentation on the update on the expert reviewer training.
Good afternoon. I'm pleased to report we had another successful expert reviewer training in February 9th of this year at UC Irvine. It was attended by over 100 physicians, and the feedback we received was quite positive. I think the training went extremely well. We did implement the new process where we're having the physicians submit an actual sample opinion, which has actually proven to be quite interesting. It's been arduous because we've been giving them individualized feedback on the sample opinions that have been provided. And I do believe this is going to be a great opportunity for us to make some amendments in our next training, because there are a couple little areas that I still think we need to see further improvement. And we are hoping to have the next training sometime in the fall, probably late October, November time period, so we can get our next 100 or so experts trained.
Where?
San Diego is where we're trying to get location with UC San Diego.
So I've attended both of these, and it's really one of the most impressive things that I've seen through the medical board. And the whole reason for these programs is that we want to raise the bar for our experts so that they understand their purpose as a consultant to the medical board. And I think you've done a phenomenal job, and I want to thank not only yourself, but your team and all the people that you recruited to speak. I mean, it truly is an impressive program. Thank you very much.
Thank you very much. It was your idea. It was a great idea.
That's why he's calling. That's why he's saying it's we can pick it.
But I had nothing to do with the actual training program itself, which you've done a phenomenal job with. So thank you very much. Is there any public comment on that issue?
Dr. Loeb,
Yes.
one of the things, though, and I think this board has said this repeatedly, and we do thank you for recommending to do this training, because the frustration that the public doesn't see is that if, in fact, the quality of our experts is not outstanding, we're often faced with having to agree to a stipulated settlement, because we find that if we were to adjudicate it even further, that our own experts wouldn't be able to support the position of the board. So I think that anything we can do to improve the quality of the experts will help with enforcement. And again, I thank you for coming up with that idea.
I agree, and it's in evaluating the efficacy of the training is what I'm really interested in right now too, and seeing these actual sample opinions has been really eye-opening. And we haven't had an opportunity to see how the training is being reflected in the actual testimony yet, because not very many cases go to actual hearing, but we'll be assessing that as well.
Good.
Yes, Dr. Levine.
One other comment, one other additional benefit of the training, I think, is it will potentially enable us to recruit more interested physicians to provide expert review if they know they're actually going to get prepared for and this is actually a developmental opportunity for them, rather than being kind of thrown into review the case and we're going to put you on the witness stand and you better do the right thing. I mean, I think it may be a wonderful marketing tool for us in terms of encouraging greater participation in the expert reviewer program.
Hope so.
Okay, with no additional comments, we'll move on to the next agenda item, which is a discussion and consideration of proposal to increase expert reviewer hourly rates upon completion of the expert reviewer training program. Ms. Sweet.
Okay. Segueing into this next subject, which I do believe will also help with our recruitment efforts and marketing efforts. And after the last expert training, discussion ensued regarding the pay our experts currently receive. Right now, we pay all of our experts $150 for record review and report writing, and $200 an hour for testimony. And as we've stated many times, we believe the expert reviewer program is among the most critical aspects of the enforcement program, and the impact of a poorly considered and articulated opinion can result in decreased public protection. Such an opinion can result in charges not being filed against a physician who has violated the Medical Practice Act, It can result in charges being filed that Ms. Shipsky mentioned that can't be supported once the charges are filed, or it can result in an accusation actually being dismissed because the expert cannot adequately testify to support his or her opinion. And you've likely seen some of these situations when reviewing proposed decisions that call for dismissal of an accusation. So to ameliorate these problems, at Dr. Lowe's suggestion, we did institute the interactive training that began in May of 2012, and we have been compensating the experts who attend this training with continuing medical education credits, and training that that the experts hopefully find informative and reasonably entertaining. Ideally, as Ms. Yaroslavsky suggested at the previous committee meeting, we could require experts to attend the training and submit a sample opinion that's acceptable prior to engaging them in a real case. And this vetting process to date has not been possible because of a variety of reasons, one of which is our lack of experts, particularly in certain specialties. And part of this problem, we believe, is our notoriously below market rate of compensation to our experts. During calendar year 2011, we sent out questionnaires to our experts asking them for feedback about their experiences as an expert. And I'll just read you a couple of these to save time of some of the comments that were received. One expert wrote, "Rate increase for time, as this time is spent away from family or other cases. My usual minimum rate is $350 to $500 an hour. Understanding the importance of medical board case reviews, a rate of $250 per hour would be much more reasonable and allow for faster reviews." Another expert wrote, "The reimbursement rate is quite low in comparison to the private market. Since it is a service, the value should likely come closer to the difference of these two extremes, for example, $350 per hour." And regarding the neurosurgery expert shortage we have, one neurosurgeon wrote that the median rate for medical legal evaluations for neurosurgeons is $500 to $800 per hour. And that while I understand medical board can't pay this rate, there would be more willingness to participate if the rates were a little higher. The board has had significant difficulty procuring neurosurgery experts, as evidenced by the few experts available in the specialty to review cases. And currently, even though we have advertised in our newsletter, now we've advertised in the American Board of Neurosurgeons newsletter, our analyst has corresponded with academic institutions throughout the state begging for neurosurgery experts, we still only have 9 at this time. So it makes it almost impossible to get an expert review turnaround in our 30-day goal when we can't find an expert, and then once the person is kind enough to take the case, we feel kind of like ingrates asking for a very quick turnaround. So we're generally looking at more like 60 to 90 days to get those cases resolved. And then we have additional problems when it comes to the point where that expert might have to testify because their time is so valuable. We don't believe we can amass a pool of qualified vetted experts unless we're willing to pay more for our high expectations. A physician's time is a precious resource, and our rate of compensation, I believe, must reflect this reality. That said, I would like to ask the committee to entertain a motion to allow staff to seek a budget augmentation to increase expert reviewer pay according to the schedule in your packet on Section 5, page 3, which in a nutshell says that after an expert successfully completes our training and provides a satisfactory sample opinion, that their pay be raised from $150 to $200 an hour for record review and report writing, and to $250 an hour for testifying, and then for neurosurgery experts only to increase their rate to $300 an hour for record review and report writing, and to $400 an hour for testifying. That concludes my presentation.
Well, thank you very much. So at this time, I'd like to entertain a motion as she proposed, to augment these rates.
Can I ask a question? Have we had any correspondence with SFMB just to find out what other jurisdictions pay their experts?
We have not.
That might be helpful for us so that we can get some kind of sense of, and because this may be what you're proposing kind of low, and maybe as a follow-up, we could find out what other states do too, as well.
Yes, Dr. Levine?
I'll make the motion.
Okay, so we have a motion. Do we have a second? Second from Dr. Levine?
And a question?
Yes.
So my back-of-the-envelope estimate is it's about $500,000 impact on the budget. Is that?
Let me look at my trustee. Yeah, maybe a little bit higher, but not too much.
Okay.
Yeah. And again, it depends. If we get an influx of neurosurgery cases, we're just basing this on our previous experience, right?
Just taking it further, we do have that money available, right, in the budget without trying to get more revenues?
I believe that is correct. No? It's not correct?
Yes.
Yes. Yes.
Executive Director says yes.
Okay, is there any public comment?
There's a legal comment, and I just want to make sure that the motion is, of course, in the form of a recommendation to the full board.
The full board, yes.
Always
We
at the
we
full
wouldn't
board.
dare take it upon ourselves to move it fully.
That's right.
Yes, we have Ms. Whitney.
To answer that
We know our
specific
place.
question, the money is not in our current budget, but we have it in our fund. So we would need an augmentation. That's why your request is to go to the full board to ask them to direct staff to prepare a budget augmentation request or budget change proposal. So we have the money in the fund. We don't have the appropriation or authorization to spend it right now.
Public comment? No public comment? Call for vote. All those in favor?
Aye.
Opposed? Abstain? Motion carries. Thank you very much. Okay, moving on to agenda item number 6. This is a discussion on history and efforts to improve retention by enhancing the investigator classification. Our Chief of Enforcement, Ms. Renee Threadgill, will give us a presentation.
Okay, thank you. Good afternoon. The chair of the Enforcement Committee asked for a report detailing efforts the board has taken to address the recruitment and retention of medical board investigative staff. The turnover of investigative personnel is by no means a new issue. This has been a chronic problem that has spanned almost a quarter of a century. Turning to agenda item 6 on page ENF 6-2 in your agenda package, I would like to highlight a few of the copious efforts of the board to improve our ability to retain investigative staff. The board has tried without much success to improve retention of investigators by seeking monetary differentials commensurate with other state agencies. A few interesting actions that we've taken include the legislature enacted SB 2375 during 89 and 90 legislative session. This legislation included intent language regarding investigator pay. The intent of the legislature that the pay scales for investigators of the medical board be equivalent to the pay scales for special investigative agents of the Department of Justice in order to attract and retain experienced investigators. Nothing ever came of that intent language. In November of 2002, Board President Gary Gitnick sent a letter to Governor Gray Davis seeking his support to overcome salary and differential inequities. The correspondence noted that it is troublesome and contrary to good management practices when a single employer, the state of California, allows some of its agencies to offer benefits in the same geographic area in which it is denied to other agencies. In January 2006, under SB 231 Figueroa, when SB 231 was enacted, requiring medical board and Department of Justice Health Quality Enforcement Section to implement vertical prosecution model to conduct its investigation and prosecutions. Throughout much of the legislative process, SB 231 contained a provision which specified that medical board investigators would be transferred to the Department of Justice to create a more streamlined and centralized enforcement system to achieve the public protection goal. However, shortly before it was enacted, SB 231 was amended and the proposed transfer was deleted. This transfer would have given investigators a pay increase commensurate to the agents in the Department of Justice. During 2009, the enforcement program contracted with CPS, Cooperative Personnel Human Services, Resource Services, to explore the possibility of reclassing medical board investigators. CPS recommended formalizing the investigator training program, which we were already in the process of doing. We had done it. And then crafting an official request for a two-stage pay differential suggested at 5% and 10% that focused on additional training. MBC investigators received so much specialized training that it seemed that they could receive additional compensation for completing training milestones. This recommendation was abandoned due to the state budget crisis and also because it did not address the complexity of jobs at MBC. Most recently, I requested that DCA submit a request to the Department of Personnel Administration to pursue pay differentials for training officers, range masters, defensive tactic instructors, and other formal training assignments. To date, this request remains outstanding. Being mindful of the economic reality, staff is making a modest recommendation to level the playing field with other state agencies by requesting establishment of differentials for training officers, range masters, defensive tactic instructors, and other formal training assignments, and that investigators receive pay differentials for living in Los Angeles or other high-cost areas where investigators in other agencies receive the same differentials. Additionally, it is recommended that staff work with the Department of Consumer Affairs to amend specifications for the investigator classification series to expand the subject areas of the degrees accepted for admission to the examination. And that concludes my report.
Okay, thank you, Ms. Threadgill. I think that it's well accepted that our investigators and the medical board do comparable work to the investigators in the Department of Justice, and there is this big differential. So it seems to me that it's very reasonable for us to consider a motion making the recommendation to the full board that we make these interim adjustments that are recommended by Ms. Threadgill. Do we have any comments from the board members? Yes, Dr. Guanadev.
Ms. Threadgill, I got two questions. One is that what's the process? If we make a recommendation to the full board and it adopts, then what happens? So how does this come true? And the second one is, again, with the same my MBA hat rather than MD hat, what's the cost?
I don't have the cost, but my recommendation essentially is that we work with the department to pursue those differentials for all investigators within the Department of Consumer Affairs, not just the medical board. So I guess it would impact every investigator that's in a current DCA investigator job class, because we use the same job classification throughout the department.
Yes.
I would, I'm fine with making the recommendation, but I would like also to know the cost at the medical board. I'm not interested in any other department, so just to be.
Yes, Ms. Shipsky.
Was the problem resolved? I know that we talked about some time ago where, in terms of trying to recruit, you were limited to taking investigators that were only within the Consumer Affairs Agency, and that there was some obviously concern.
No, that was during the freeze.
Are you still limited just to 10?
No, there's no freeze. Now we have to be concerned with the restrictions on hiring the SROA because of the other individuals that are being laid off in other departments.
You want to explain that a little bit?
Well, there are, in the past, there were individuals that were laid off at Department of Justice, which we gladly hired, and as soon as we got them on, we learned that they were being offered their jobs back, so we lost them again after having invested a lot of work in their backgrounds. And now there's a big layoff going on with the Department of Corrections, both with parole agents, and so we're forced to hire the SROA people before we can look to anyone else on the list, which we're doing now.
Okay, well, and again, but hopefully at some point when you do some recruitment, you'll be allowed to go outside to the bigger recruitment pool of special investigators from other agencies, federal agencies and others.
They'd have to be on the list. They have to meet and meet the minimum qualifications, but that's after you exhaust the SROA list and the reemployment, I think, list for people who've actually lost their job within state service. So,
okay, thank you.
So, do you have more comments? Yes.
No, just.
Okay, so we have a motion.
Yeah, make the motion at the same time that as it goes through, I would like to see the cost.
Right, we need to include that in the recommendation. Okay, so is there a second?
Second.
Second. Public comment? Okay, all those in favor of making this recommendation to the full board, aye?
Aye.
Any opposed? Abstain? Motion carries. Thank you.
thank you.
Okay, moving on to agenda item number 7, discussion of priorities established in the Business and Professions Code, section 2220.05. Ms. Katie.
Thank you. At the last Enforcement Committee meeting, a request was made to explain to the committee how the board interprets its priorities that were established in statute. In 2003, Section 2220.05 was added to the Business and Professions Code, and that identified that cases involving the following allegations are to be handled on a priority basis, with the highest priority being given to cases that involve gross negligence, incompetence, or repeated negligent acts that involve death or serious bodily injury to one or more patients. All complaints alleging that the quality of care provided by a physician was negligent must go through the same triage process and review process in the complaint unit before being sent to investigation. However, those that allege that the physician's care resulted in serious bodily injury or death are flagged as urgent and are given on a priority base, are given priority status during the medical review phase. The other case types that have been designated as priority are practicing while impaired, either by drugs or alcohol, sexual misconduct, or excessive prescribing. In the complaint unit, these cases are assigned to an urgent analyst who immediately refers the case to the field for investigation without any workup in the complaint unit. The board also considers complaints that allege physician impairment either by substance abuse, mental, or physical illness to be the next highest priority, along with cases alleging unlicensed practice or aiding and abetting the unlicensed practice of medicine and criminal conviction cases. The majority of these case types are referred directly to the field without any kind of triage review in the complaint unit. Complaints that involve physicians that are currently on probation are also given a priority, but they undergo a triage review in the complaint unit prior to being referred to the field, depending, of course, on the nature of the allegations. When complaints are referred to investigation, they are reviewed by a district supervisor and by the Deputy Attorney General on intake to identify those that represent the potential for patient harm or may be considered possible ISO material or considered for a possible ISO. Finally, I wanted to give you a list of some of the other kinds of complaint issues that are received in the complaint unit. Most of these are designated as routine matters. They undergo a triage review in the complaint unit, and very few of them would result in the referral for a formal investigation. Any questions about handling priorities?
Any discussion amongst the board members? We have a public comment from Genevieve Claverol.
Good afternoon, Genevieve Claverol. I was wondering if the item you have are posted in priority. And personally, I think like one of the things you did not mention at all was disruptive behavior from physicians, and apparently that's becoming quite a big issue at times. And also that I felt the unlicensed to practice medicine should be at the beginning, because if you don't have that, then you shouldn't be have the all other one under it. So I don't think that's, in order of what, importance. And I wanted to know if it was any order of severity.
On the second slide that talks about the urgent cases, that's just a list. It's not given a priority order.
That's what I wanted.
Yeah.
Thank you.
Okay. No other comment? I guess we can move on to agenda item number 8. This is a discussion of the Workmen's Compensation Utilization Review Process, investigation of complaints, and we're going to hear from Ms. Katie and Mr. Hepler.
The committee has asked for a briefing on the topic of utilization review in response to public comment during the last meeting. Concerns were raised regarding several issues. First, does the board consider utilization review to be the practice of medicine? The board has addressed this issue by stating that utilization review decisions constitute the practice of medicine, and that a physician who reviews and makes medical necessity determinations is considered to be practicing medicine. The second issue is, does the board have jurisdiction to investigate complaints involving decisions made by physicians performing utilization review? The board receives a very small percentage of complaints regarding physicians who perform utilization review. This function is used in a variety of settings. Generally, complaints received by the board tend to fall into two general categories. The first is the denial of coverage for service or procedure by an insurance company. Complaints are received from either the patient or the physician providing care to the patient whose request for authorization for treatment has been denied as either being experimental or deemed not medically necessary. The legislature addressed this issue and declared that decisions about medical care should be made by physicians and other healthcare providers. The criteria or guideline used by health plans, insurers, and IPAs to determine whether to authorize or deny services must be developed with involvement from actively practicing physicians and must be consistent with sound clinical principles. The guidelines must be evaluated and updated annually and must be filed with the Department of Managed Care for HMOs or the Insurance Commissioner. By law, only a licensed healthcare professional who is competent to evaluate the specific clinical issue involved may deny or modify requests for authorization based on medical necessity. The decision of the reviewer must be communicated to the treating physician and the patient and must contain a concise explanation of the reasons for the decision, a description of the criteria or guideline used, the clinical reasons for the decision. The name and phone number of the reviewer responsible for the denial or modification is provided to the treating physician. Information about how to file an appeal or a grievance must also be provided to the patient and to the treating physician. Patients have the ability to appeal the decision to appeal the denial of services to the Department of Managed Care or to the insurance commissioner after they've exhausted their appeal options through the carrier. The second type of complaint or utilization review function is the denial of coverage for services related to a workers' compensation injury, and Kurt's going to address that.
Thank you, Ms. Kitty. Mr. Chairman and members, first let me throw a few disclaimers out at everybody. I'm not a workers' comp attorney, nor did I stay at Holiday Inn Express, nor did I play one on TV. And the issue that I have was asked to talk about sort of not on the validity of the claim, not how the UWC process, workers' compensation process works, but I consider it from the perspective of inputs into the board. And by that I mean we have a series of inputs into the board for our disciplinary process. We have complaints, we have 805s, we have 801s, we have self-reporting inputs as well. We have there's some legislative consideration of modifying coroner's reports and also to provide additional inputs into the board. The issue is kind of complex because the board has essentially, as Ms. Katie said, number one said that the practice of utilization review is in fact the practice of medicine. We say that on our website because we say you can't do it with a retired license. You have to have license. We also in the past have supported legislation that would establish a requirement that a UR physician, a utilization review physician, be a duly licensed California licensee. That is, they would hold a physician and surgeon certificate issued to the board by the board. That's not currently the case. And so we sort of find ourselves in a paradox because we have this thing that we'd like to see everybody California licensee, but in fact, we would sometimes decline to have jurisdiction over a complaint filed against a UR physician. So I looked at it from the perspective of essentially there's three parties in a UR dispute, and that would be the injured worker, sometimes called the claimant, the treating physician, and the UR physician, who again need not be a California licensee. And so we have this issue of, as I understand it, that somebody would, either the physician could, the treating physician, or the patient, the claimant, the injured worker, could file a complaint against the UR physician, presumably for denial of treatment, reduction of treatment, modification of the treatment plan. And then the question comes up, what does, in fact, the board do with that? And the reason I say that is the workers' comp is, in my opinion, a little bit of a closed system. When there's a UR disagreement, the statute that invokes the utilization review process talks about a process by which those are resolved. That process, in my opinion, does not include the medical board. It includes lawyering up, it includes getting maybe a competing opinion, getting a lawyer, going before the Workers' Compensation Appeals Board, having the matter heard. It does not mention going to the medical board. And not to say that, that couldn't be a reasonable interpretation, it just is not there right now. The second thing is, from a pure public policy perspective, there is a complaint process as you look to the attachment, and I apologize, I've updated my memo to the April 22nd, 2013 date because the previous memo I think wasn't signed and there was a couple of typographical errors and a few words. I'm not the world's greatest typist. There's a couple of words omitted, but it stands for exactly pretty much the same proposition. That there is a complaint mechanism already, not with us, but with the Department of Industrial Relations, who can impose a monetary fine in the cases where UR goes awry. So as we look at it, clearly there may be value to an input, but the question is, in a closed system like UR, what is the medical board's jurisdiction? And as I point out in my recommendation here, that it continue to establish policy of performing a preliminary analysis of the complaint, and if the complaint involves a UR issue, not a denial of coverage issue, like I should really be covered for this and I'm not, but if something that affected the treating physician, didn't do something that's within the standard of care. Now, if we talk about the standard of care, you'll know from your work on the panels that to find out the standard of care, we solicit an input, the input of a expert who testifies to what the standard of care is. In some cases, in a lot of cases, that question over standard of care is in fact answered in a workers' compensation proceeding because they have the MTUS, the treatment guidelines, or the ACO, and the guidelines already established. So there's the standard of care. I would respectfully suggest that if in fact the board wanted to assert jurisdiction explicitly over these kind of issues, that it do so in a statutory change by saying, and the medical board shall have jurisdiction over that. I think that would clarify the issue. Clearly, the medical board has jurisdiction over, normally occurring complaints or whatever. The issue is in a system whereby there's already a mechanism established to address complaints, does the medical board have a jurisdiction there? I would respectfully suggest, out of abundance of caution, if the medical board wanted to assert jurisdiction over those complaints, it'd seek a legislative change to explicitly do that. So, again, I'll be more than happy to answer any questions that any of the members may have. Ms. Katie commented this is a relatively small number of complaints, I believe. So with that, I'll be quiet.
Okay. Discussion from our board members. We'll start at the end with Dr. Levine.
Yeah, so I'm trying to follow the logic chain here. We've established that utilization review, to the extent that a licensed physician can deny or delay treatment recommended by a treating physician, is the practice of medicine.
Correct.
And leaving aside workers' comp, because I think when we heard testimony about this at the last meeting, the request to add it to the agenda was broader than the workers' comp issue. It was about utilization review in general. So to the extent that a utilization management or utilization review decision results in denial or delay of care and harm to the patient, but to me the chain of logic is that doctor who had the ability to say no engaged in some activity that caused harm to a patient. So to say that we have no jurisdiction when a patient is harmed, I mean, it may not be a huge number of cases, but once we've said it's the practice of medicine, how do we not allow a complaint to be brought forward?
Respectfully, I think that's the area of tension because, first of all, we would have to do some sort of preliminary triage to figure out if the person that the complaint is about is in fact a California licensee. But let's assume for the sake of discussion that they are. The reason I am hesitant, and I understand the logic here, it's a little bit even more complex. Here we say it's a practice of medicine. The board has previously said, and everybody doing it ought to have a California license. But then we say, well, okay, that's all well and great, but if you file a complaint, we hit the brakes and it hits a brick wall. I think the issue is that the remedy in some regards, the closed system that I talk about, the remedy for an untoward decision or something untoward decision coming out of UR is in fact using the process prescribed by law, which doesn't include the medical board. So that's the tension that I see.
Well, these are two issues. I think that we're getting things confused. One is, there's a difference between what the patient wants and what UR says, and that dispute resolution occurs within their own system.
Right.
But if the UR physician is practicing medicine in a way that we think is unsafe, then that's something that the medical board can deal with, and that's totally separate. And I don't think that that should ever go away, and that message needs to be sent to all UR physicians that they still are under the medical board for the way they practice medicine. Does anybody disagree with that?
Well, I thought that's what I was hearing, the disagreement that we legally, even though we call it practice of medicine, but the complaint can't be resolved by us. That's why it didn't make sense to me either. Take workers' comp is maybe a closed system, but like Dr. Levine, my point is utilization review, denial by a physician and another physician request is practice of medicine. If there is if that delay in care or denial of care causes harm to the patient, that is practice of medicine. So why can't the medical board be looking into it?
Because we're not in the business of dispute resolution. All we're doing is we practice and protect people against bad doctors. And that's what we want to continue to do, and we want to include those UR doctors. I think that should be our position. Yes, Ms. Shipsky.
I think you're agreeing with me, yes. That's what, you're agreeing with me. Actually, those doctors should be included. That's what my point is, that we should, if they deny care or delay care for some self-reasons, whatever it is, I think we should be looking into disciplining those doctors. That's what I'm...
Yeah, because sometimes, you know, the UR doctors are conflicted because their goal is to their employee, you know, their responsibility is to their employer, and for their employer, many times the goal is not optimal patient care, it's improving shareholder value, which means making more money. So, you know, I think that, you know, we're not in that. I don't think the medical board wants to get into that whole business. We want to just regulate doctors. And if you practice bad medicine, whether you do surgery or whether you do UR, you're still under the medical board, and that's what we want to stay with. Okay, other comments from board members? Yes, Ms. Shipsky.
Well, actually, I have played a workers' comp attorney, not on TV.
Okay.
The difficulty about the UR system is that the majority of these UR, first of all, most UR in workers' comp is not done by doctors.
Right.
It's done by nurses, period, and sometimes even clerks.
Right.
Okay, because in California, they take the ACOM guidelines, they look at it, and they go, nope, we're not going to approve that. The difficulty is that we really, as a medical board, need to maintain, obviously, jurisdiction about the quality issues, and that's not something somebody can file with DIR on. A denial of benefits has nothing to do with any allegations that because the delay in treatment, this is what happened, that. The other issue is the fact that the majority of UR physicians are not in California. And at some time, legislatively, we need to deal with that, because we would not allow that to happen for other insurance issues. But, you know, these physicians that are hired, and we can get into the whole corporate practice of medicine issue too as well in this, that they do take directions, that they're not even California physicians, so they're out of our jurisdiction somewhat. But I think for those physicians that are in California who really do this UR, I think it's important that we send the message. The medical board can be involved in matters of patient quality, the care that's given to that patient, if it's appropriate or not.
Yes, Mr. Sewell.
I too had the pleasure of practicing workers' comp law for 6 months and was grateful when I was reassigned to another team, because it is a difficult body of law. I mean, it's all code driven with a few key cases that guide everything. You go to the workers' comp, your local's workers' compensation board, it's like the Wild West in there. I mean, there's just so much going on. And the only thing I would say, and I think it's cautioning everyone, workers' comp law, those procedures are well established. It's a unique, discrete process with employers and corporate, asserting jurisdiction, however you want to describe it. I don't know, it seems complicated to me. And I don't know how it just seems, very challenging.
I would agree. I think that's why you say out of abundance of caution, if the board wanted to do that. And I certainly understand the public policy concerns. And again, this is a legal perspective, certainly not the policy position of the board. In that you may want to consider, like I said, an explicit statute to do that. I think that one could work hand in glove well with the California licensee requirement. I would just be concerned that if we were to take, again, there's various stages, as Ms. Katie, I think, pointed out a couple agenda items. Again, there's the complaint process, and then that morphs into the disciplinary and the investigation process. What we're talking about is sort of the de facto, we're not going to go any further because this is a workers' comp complaint. I think that's what we're really talking about here. I think if we wanted to, because that ultimately may lead into discipline, I think the medical board, in a sense, would want clarification by statute or some other means that, in fact, yes, this would be the legislature's directing you to take jurisdiction over that kind of complaint.
We do receive a number of complaints that that all focus on the same, surround the same issue. So we need to make sure that we're going to be respectful of the other types of issues. Independent evaluations by a physician, we look at it from the same perspective. From the complaint, we try to drill down to what's the doctor's role in that patient care scenario. If their role was limited to providing just an opinion about the patient's care, an opinion about additional need for treatment, opinion about whether a benefit is needed or whether they're disabled or not, we have no authority to overturn that decision or influence that decision in any way. So in all of those types of scenarios, we sort of take the same approach. It's an objective opinion about a patient's condition, and there are remedies that are available should that decision be challengeable or appealable. We also have to look at what priorities have been established, both statutorily. We always focus on those that represent the greatest potential for patient harm. And we focus on fitness for practice. We focus on those that have a direct doctor-patient relationship that have directly affected the patient's care. So those are some things we ought to think about as we're moving down this path.
Thank you. For the people that just came in, this is the Enforcement Committee meeting. We're running over. I know you're expecting the full board meeting, and that will start as soon as we finish. We have some public comment and then another agenda item. So for public comment, we have a team that's going to address us. This is Yvonne Chong and Steve Katolika.
Yes, sir. Thank you, Dr. Lowe, committee members. I appreciate Dr. Levine's perception in the discussion. We think that the question that was answered in the memorandum was the wrong question. The question that was raised in our testimony last month, or excuse me, in January at the last meeting, had to do with what is the jurisdiction of the board with respect to a complaint, essentially of malpractice. If UR is in fact the practice of medicine, then in fact there should be a way for an aggrieved injured worker, in this particular case, or any patient, to seek some redress from the board and some discipline of the physician who's responsible for that practice. I told the committee in January about a California licensed UR physician who was working on behalf of a work comp insurance carrier that decided to cut a chronic pain patient off cold turkey from opioid therapy regimen that he had been following successfully for a number of months. And subsequently, due to the inevitable and severe physical and mental withdrawal, this individual landed in the ER. We understand that that individual actually filed a complaint with the board and was told that the board had no jurisdiction, partly because of the complaint, I think the confusion that we experienced in the conversation earlier. The board's responsibility for patient safety is even now more acute with the implementation of a completely anonymous independent medical review process within a workers' compensation system. And we urge the board to actively engage in this issue and assert its responsibility to protect the public. Mr. Hepler, the medical board senior staff counsel, provided that memo, and as I mentioned just a moment ago, we believe that it went the wrong direction and is really not addressing the question that we had asked be addressed. That said, we want to compliment him on even attempting to try to discern how UR is done in workers' compensation. It's not easy. It's very litigious. But our question had nothing to do with whether or not the board has the ability or the right to overturn a denial or a delay or a modification of care. That is not the question. The problem that faces the medical board, the problem that has to be addressed, is the board's jurisdiction over a licensee when a patient experiences any harm as a direct result of the licensee's denial of care. Harm, such as an unnecessary cold turkey withdrawals that land the person in a hospital in serious or maybe even critical condition, subjecting the patient to deterioration of their overall condition and their ability to return to work, not to mention, if you don't mind talking about money just a little bit, the insurance carrier's extra costs because of those issues that come up. Following upon the board's longstanding policy that UR is the practice of medicine, UR doctors must be held accountable for the results of their decisions just as any other practicing physician would. Essentially, the memo states that UR complaints can be boiled down to whether a standard of care was met or not. That's only partially true, And as I mentioned, that is not the main issue. The main issue is accountability for what happens to the patient after the UR physician denies care. If a patient, under the care of a licensed physician practicing medicine under the jurisdiction of the board and practicing within the standard of care, experiences an adverse outcome, is not the treating physician still accountable? Cannot a complaint be lodged with the medical board and perhaps a lawsuit filed as a result of the adverse outcome? It's no different when a licensed physician practicing medicine as a UR physician decides to deny authorization for care, and as a result, the patient experiences the same adverse outcome. We believe that the memo assumed that the UR physician in California work comp system hides behind or is covered by the employer's immunity from tort liability, and that should not be the case. If I might put it in terms of a question, does the board walk away from a complaint that is subject to a malpractice action by saying we can't rule in the civil lawsuit? That there is a remedy to obtain care for an harmed patient does not mean there isn't a board role with respect to the licensee's violation of the standard of care. The board must be equally engaged whether the care is paid for by a group health or commercial health care plan or a workers' compensation insurance carrier. There's nothing about the fact that a UR physician is employed by a work comp carrier that relieves the board of its obligation to enforce its authority over the licensee's conduct. If that were true, then every physician that's contracted with the employer's medical provider networks, which is a closed system of care, could also avoid having any malpractice insurance because they're hiding behind the employer's immunity. And of course, we know that's not the case.
So your time is up. You want to?
I'd like to make our request to the committee that they recommend to the whole board that it quickly and unequivocally reaffirm its jurisdiction over the medical decisions made by California licensed physicians and surgeons who conduct utilization reviews. And because of the apparent internal confusion over the policy and jurisdiction, we also request that the committee recommend to the board that it create a plan to direct enforcement staff to implement enforcement oversight over these decisions that have adverse effects on injured workers. And for the sake of California's injured workers, the board must communicate directly to the workers' compensation community its standing policy and enforcement procedure, together with, we believe, a simply stated set of instructions that can be provided to injured workers when they feel that they've been aggrieved by the actions of a licensee practicing medicine as a utilization physician. Thank you very much.
Okay, Mr. Hepler, do you have a comment? Okay. Okay, so Yvonne, did you want to make
my comments are very brief.
Sure.
Yvonne Chung with the California Medical Association. Thank you to everybody who made my points so much better than I would have made them. My comments will be very brief. We would support Mr. Catalga's request as well in terms of the specific recommendation that we'd like the enforcement committee to pass on to the medical board. Full board tomorrow. Just addressing a couple other issues. On the issue of the fact that the medical board does have a lot of priorities, we understand that, but I think that I want to clarify that we're not asking that this be moved to the top of the list. All we're asking is that it be clear that the medical board does have full jurisdiction, and the extent to which that falls in the line of priorities is another issue, but that is not a reason to exclude it from the medical board's jurisdiction. And finally, I would like to remind the board that this issue was raised as part of the medical board sunset review as well, and the recommendation from through the Sunset Review Committee was that the medical board take action on this issue and clearly specify that the utilization review is the practice of medicine and should be enforced as such. And we look forward to your response. Thank you.
Appreciate your comments. Next public speaker is Genevieve Claverol.
Good afternoon, Genevieve Claverol. I am very pleased to hear that you feel that utilization review is a practice of medicine, because I will not be the cripple I am today if indeed the utilization review could have been a challenge on a lot of my treatment. And you said you have not heard a lot of complaints from patients not receiving treatment. I think the amount is very enormous, but most individuals who are injured on a workforce know that they have some avenue to complain and do something. For myself, who have not received the appropriate treatment, I am an RN. I've been director of nurses many times in my life. I am a PhD in hospital management, and I could never receive the care because utilization review was accepted as fait accompli. And I think it's criminal what's going on right now. And the reason myself I am fighting is because I can do it, but there's a lot of individuals who do not have the background that I have, who absolutely are, their life has been totally ruined, and can no longer work. Myself, I feel that even now, actually, yesterday I got an email for utilization review. I'm not entitled any physical therapy because I have already used my 24, I have had multiple surgery since my initial, therapy. I have had a bone transplant. I have had, fusion in my leg and so on, and I have refused all therapy, and that's happened all the time. I will love that you take as a project to really make utilization review a medical practice issue for the people who really are in pain all their life. And thank you so much for listening to me.
Thank you. And our final public comment will come from Julia DAngelo, Falmouth.
Good afternoon, Dr. Lowe and members. Julie DAngelo, Falmouth from the Center for Public Interest Law. I fully understand and appreciate that workers' comp is a separate animal from this board and that it is administered by multiple other agencies. However, UR is the practice of medicine. And if a UR physician continuously refuses to allow medically necessary treatment to injured workers, what can or will the Department of Industrial Relations do to that doctor? The memo says that DIR might fine the doctor. Do you ever find out about those fines? Can it disbar him from being a UR doctor? And if so, do you ever find out about those actions? The bottom line is that you are the only body in California that can impair a physician's license. And if some other agency is administering a process that identifies potentially dangerous physicians, you should figure out how to get that information. It's like the 805 process, where hospitals are supposed to be reporting to you adverse peer review actions that they have taken against physicians. UR is a medical decision with medical consequences. At your sunset hearing last month, this board was criticized for not being proactive, and I think the legislature might like a more proactive approach as opposed to a we have no jurisdiction approach. If that UR doc is licensed in California, you do have jurisdiction over him, and you ought to figure out a way to get information from the Department of Industrial Relations about those physicians who have been fined or disbarred for UR work, and you should assert your disciplinary jurisdiction over those doctors. Thank you.
Appreciate your comments. So I think it's proper at this time that we enter, yes.
Just want to make a motion.
Okay, so I think it is appropriate at this time that this committee make a motion to the full board to reaffirm that, in fact, utilization review is the practice of medicine, and we maintain jurisdiction over their medical license just as they would be for any other specialty. But again, just to clarify, we're not in the business of dispute resolution. In other words, we can't solve those problems. That's not our job. They have their own channels to settle those things, but if the UR doctor was practicing medicine in a way that is truly malpractice, you file a complaint or we get notification through something like an 805, and then we will investigate and we'll have our consultants and experts look at it just like we would any other case. I don't think the medical board feels differently about that issue, so I'll entertain that motion.
Thank you, Mr. Chair. As I mentioned, delay and declining care is practice of medicine, so let the medical board recommend to the full board, let the committee recommend to the full board that utilization review is practice of medicine, and direct the staff to come up with the appropriate guidelines in disciplinary actions, just like any other physician practice, for the next board meeting.
Yes, Dr. Levine.
And a friendly amendment, and to clarify any necessary legislative or regulatory changes that we might need to actually make that happen.
Yes, with that amendment. Is there a second?
Second. Quick question.
Yes.
On the enforcement side, in terms, we require that where physicians practice, that there must be a posted information that they are regulated by the medical board. So I would hope that that's being posted in worker comp clinics, and/or that the physicians are disclosing that on their sign-in sheets. That's what some physicians are doing now. Instead of posting it, they're actually, when you sign up, they let you know that they're regulated. So I'm hoping that we're enforcing that provision.
Any of the treating physician relationships, which would be the clinics you're talking about, they do post that.
No, I think Ms. Chipsky's talking about the decision to modify or deny treatment. That's when the medicine happens, correct?
Right, but that often, these are often directed, these are physicians that are directed as a consequence of the UR, but I just want to make certain that workers' comp clinics and those worker comp physicians who do nothing but workers' comp, that they still, if we're indicating that for the purposes of UR, we are asserting that we have jurisdiction under that practice of medicine, that in fact that they are following the same as other doctors have been required to do in the posting, that they're regulated by the medical board.
Okay, thank you. Public comments regarding these motions? No public comment. We'll take a vote. All those in favor, aye?
Aye.
Any opposed? Any abstain? Motion carries. We'll make that recommendation to the full board tomorrow. So finishing up, we have one additional agenda item, and this has to do with the establishment of a task force to develop and address the best practices related to prescribing controlled substances to relieve pain and examine the Medical Board of California guidelines. And so I guess they've asked me to talk about that. So this agenda item, the establishment of a task force to examine the pain management guidelines relating to prescribing controlled substances, arose from concern regarding the prescription drug overdose, quote, epidemic, end quote. Last month, the board co-sponsored the Pain Summit in San Francisco, and it was a huge success, as evidenced by the number of people who attended. More than 400 people registered, and there was no additional room. So various presentations were given from a variety of experts relating to prescription drugs, law enforcement entities, pharmaceutical representatives, and regulatory agencies. Many of the statistics given at the summit were quite alarming. Prescription drug overdoses have now overtaken motor vehicle accidents as the leading cause of injury-related death in the United States. This is an issue with a variety of contributing factors, and one thing is for certain. It is an issue that has been at opposite sides of the prescribing spectrum for over the years. To give you some background, prescription drug regulation came to the forefront in the 1970s with the Federal Comprehensive Drug Abuse Prevention and Control Act, which spawned the Uniform Controlled Substance Schedule. Drugs were scheduled based upon their potency, addiction, and abuse potential. So in California, Schedule II drugs had to be written on a special, quote, triplicate, end quote, form, and databases were maintained to track these drugs. So that was in the 70s. In the 1980s and early 90s, much attention was given to the concern that too many patients suffering from intractable pain conditions were being under-medicated. There were successful lawsuits alleging patients who were dying of cancer who were left to suffer because of physicians' fear of the law enforcement scrutiny for prescribing scheduled drugs. So in 1985, the medical board created guidelines for the treatment of chronic intractable pain, but very few practitioners implemented the guidelines. So in 1990, the Intractable Pain Treatment Act was implemented when studies confirmed that physicians were under-medicating patients, and this was largely because the physicians feared regulatory scrutiny. So Business and Professions Code section 2241.5 was derived. This is an important section because it states that no physician and surgeon shall be subject to disciplinary action for prescribing, dispensing, or administering dangerous or prescription-controlled substances for a condition causing intractable pain when certain conditions are met. So in a nutshell, most of that criteria is set forth in the pain management guidelines the board first published in 1994. The guideline includes taking an adequate history and physical exam, having a treatment plan with objectives that is individualized to each patient, providing the patient with informed consent, periodically reviewing the course of treatment, obtaining a consultation as appropriate, keeping accurate and complete records, and complying with controlled substance laws. In 2002 through 2003, a task force was convened to revisit the guidelines. The task force did not recommend changes in the guidelines, but annotations were made to each guideline and investigation standards were set forth. So several other pieces of legislation followed. One called the Pain Patients Bill of Rights, which exempted physicians treating terminally ill patients from having to use triplicate or special prescription forms. In 2001, physicians were required to complete 12 hours of CME in the subject of pain management. And I think this was tied to actually their renewal of their medical license. In 2005, triplicate prescriptions were eliminated by SB 151, and all controlled substances prescriptions versus only Schedule II drugs could be written on a tamper-resistant form. This was largely to take away the stigma of triplicate prescriptions and some physicians' reluctance to use triplicates. At one point, the board's funding was attached to investigators receiving training on conducting pain management investigations. So now we get to 2010, where there were over 38,000 unintentional drug overdose deaths in the U.S., over 22,000 of those attributed to prescription drugs. Drug-induced deaths became the leading cause of injury-related death, beating out motor vehicle accidents. Studies show that prescription drugs are the gateway drug to heroin use. The economic impact is also devastating. Obviously, it's time to closely look at how the medical board is addressing this in our investigations and in our policies. I would like to solicit volunteers to work with our staff on a task force to determine if changes in our policies relating to investigating these cases are necessary. We also need to assess whether or not changes need to be made to our pain management guidelines to make sure certain they comport with the changing times. I'd like to hear from our board members on this committee, and Ms. Jaroslawski's in the back with her hand up. Yes. I'll volunteer. Oh, you'll volunteer. Okay, we have one volunteer. Do we have another?
I'm going to make a motion first so that we can discuss it to make a motion to incorporate Dr. Lowe's recommendations.
Second that. Just to comment, I think it is, we went from pain management and not getting enough pain medication to really the prescription drug abuse, you can say, at all levels. Patient level, doctor level, family level, everywhere. I think it's time we seriously look at it is important. I think pain was important, but at the same time make sure that patients with pain don't suffer. I mean, this was done at Kaiser system where they significantly cut down the number of prescriptions by educating the doctors and implementing what we are talking about here. So I'm totally there, and if I would if Dr. Bishop doesn't mind, I would like to volunteer him for this.
So I think you mentioned many of the stakeholders. I think we shouldn't forget about the pharmaceutical companies who have been very clever and developed new forms and new delivery systems for pain medications, which were very lucrative. And so I think a lot of people have some responsibility in this area of abuse. So we have a motion, we have a second from Dr. Levine, and we have volunteers, Ms. Jaroslawski, Dr. Levine, and Dr. Bishop. Do we have any other volunteers? And here's another, yes.
Could there be some sort of a registry or something where we could have people sign up? Registry?
A what?
To be on this task force? Yes. I'm sure we can develop it. I think we can give you a contact at the medical board to call. Okay, it'll be an open meeting. Yes, Dr. Levine.
Yeah, can I make a recommendation that we actually think about inviting interested parties to participate and then convene a meeting? Because I know that certainly the California...
Do I have a volunteer to be chair of that task force? Do we have volunteers? How about a chair?
Ms. Yaroslavsky.
Okay, so Ms. Yaroslavsky is offered to be the chair of this new task force, which I know will be extremely effective and efficient.
I would second the motion of inviting the interested parties.
Okay, good.
And will that include looking at the additional issue of, and I don't know the correct legal description of this is, but using, we've been accused of not using suspense orders as much as we should be able to do that if in fact we do come upon a physician, and that has never been, I think, really addressed. And
Well,
I don't know
hopefully that can be addressed in the task force.
I'm looking to legal counsel to see if that's something in that.
The utilization of the ISO process in this regard.
Absolutely.
I think the task force / committee / interested parties meetings could certainly address sort of the remedies available to that sort of thing when they found a physician with, or physicians or other licensed healthcare personnel prescribing inappropriately or excessively.
And I think that'd be very helpful, not only for the board, but for the public, so that we can see what those parameters are, because that has been a public issue raised, and without any kind of defensive response about, the limitations. So I think we need to get that out on the table.
Thank you very much. So no further discussion, public comment, yes, one public comment from...
Two, I think.
Oh, two public, I'm sorry. Two public comment. Yvonne Chong from the CMA.
Good afternoon, Yvonne Chung with the California Medical Association. Thank you to this committee for taking the initiative to establish this task force. I wanted to let you know that CMA has already started on this effort as well, and we would be more than happy to participate in this process. We've developed a fairly substantial database of resources and academic journal articles and other resources on this area, precisely looking at whether or not guidelines need to be developed. We're also expecting to have a white paper developed hopefully this summer. We're working on it right now. We're in the process of finalizing it. That does take a look at best practices for physicians who are engaged in pain management. The target audience is kind of the general physician, not necessarily the pain management expert. And our team of physicians that have been working on this paper include experts from nationally recognized experts in pain management, occupational medicine, addiction medicine. So hopefully we will be able to share our resources with the medical board. Thank you.
Well, thank you for your comment, but I think importantly we must include the primary physicians that take care of the patients, because many of the pain medicine physicians don't write for the chronic pain meds. They expect the primary care physicians to do it, and so that's kind of a source of, discontent.
Right, and that's one of the tensions we're trying to work out in our paper is, at what level do you write so that, for the primary care physicians, what should be the relationship? At what point do you refer to a specialist, and trying to make that a little bit more clear, particularly for physicians who may be very rarely prescribing pain medication.
Well, I've been working very hard on something to measure pain. So once I have that, then we'll solve the problem. Okay. So our last public comment is from Genevieve Clavel.
You're getting to pronounce my name better every time.
I did take some French, but I never did very well there.
Well, decision we have traveled again. Actually, I have been very involved on that issue of chronic pain and opiates use and so on. I'm also a journalist, an economist, and I had written two papers actually. One is a great opiate debate of 2012, was very recently, and one on chronic pain. I have attended many of the meetings on bills having to do with opiates. I would love to participate to your task force in a measure you will allow me to. And I think it's a lot of misunderstanding. And many times there is abuse also because the physicians don't know how to prescribe and so on. Like an example in my case, I have one physician with an orthopedic physician. this is the only physician I allow to to write any pain medication for. But every time I have surgery, the surgeon will say, "Oh, how much Vicodin?" They volunteer to give, and I think it's what's happened often. You have patients who have a regular, physician. They are on pain medication. They go to the hospital for another procedure, and the doctor will push the drug down, to them. So I think that's very important, and I think is why we have to have a bank of information where people know exactly what kind of drugs the patients are getting and how often. I think that will cut a lot of abuse, and also to teach a patient how to utilize the pain medication. And myself, I have a very large dose of morphine around the clock, and Percocet, and lidocaine patches. That's why I'm here standing and talking. But I think we really need to keep a look at that, because there is a lot of abuse, because people don't know of alternative also. Sure. And I think, like I said, I have done a lot of research on that subject, and I think you need to prevent it. But I think we do not need any kind of article who give thousands of people die, of overdose of opiates. Because now we are having physicians who are freaking out and refusing to prescribe drugs. And actually last week, my daughter who also has fibromyalgia like I have, the doctor said, I'm going to put you on detox. If I had not been there, she will have committed suicide that day. So I think, a lot of teaching has to be done. But, in the state of California, the article showing where 1,000 some deaths over 5 years in 4 counties, those 4 counties in the state of California represent 22 million individuals, and many of them are in pain.
Thank you. Okay, so final thing is agenda items for the meeting in July 2013.
Dr. Lowe, before I think we get to that point, Ms. Dobbs, correct me if I think we have an outstanding issue still on with item 10, the SB 41441. I believe one of the things that should have been discussed there was, I believe there's a request by the Attorney General for comments on the request for a legal opinion made by the Board of Pharmacy is regarding to SB 1441 and the applicability of the standards to the Pharmacy Board, if I'm not correct, Ms. Dobbs?
Well, it's all of the boards.
To all the boards. And so the AG, the Pharmacy Board has requested a legal opinion from the Attorney General on, from the Pharmacy Board's perspective about the applicability of 1441 and the obligations of the Pharmacy Board. Pursuant to that request, then the AG's office then sent a letter to the Medical Board asking, hey, Medical Board, do you wish to comment on this upcoming opinion?
So where are you going with this?
So for us to comment, I would, legally or whatever, the question would be if you want legal counsel to comment upon that, we would have to have, I think, the board direct its legal counsel, all of them, to comment about this. In light of what happened and the discussion, excuse me, the action taken by the board, perhaps I would respectfully submit that perhaps the medical board should perhaps want to focus its efforts on immediately progressing and commencing the regulatory process, and perhaps not immediately addressing.
Mr. Chairman, to that point, our actions are speaking louder than words. Let that as our response to those questions from a unit within the Attorney General's office. I saw the same letter. We're commencing the rulemaking process. We've gone on record. We're embracing 1441. It'll be up to the Attorney General's office to give their legal advice, but we need to start the process.
Well, I agree with you, but I think that, Kurt brought up some good points, and maybe he could write a memo outlining the logistics and his thoughts, which he gave to us, which I found very beneficial and might be very helpful in guiding them.
Or make a request of legal counsel to draft.
I have to say, I have some apprehension given how well I did on the workers' comp memo.
So, Ms. Shipsky, do you want to make that as a formal?
Yes, I will make that motion.
Okay, is there a second?
We request of the board's counsel to draft the appropriate response. reflecting the actions taken by this committee.
Okay, good.
today.
And we have a second from Mr. Sewell, and discussion amongst the board members.
And we
None?
will make that recommendation to the full board that they concur in this.
Okay, no public comment? No public comment. All those in favor, aye?
Aye.
Aye.
All those opposed? Abstain? Motion carries. Final agenda item is agenda items for the July 13th meeting of this enforcement committee. We have a number of items that we'll include, but are there any additional ones? Okay, great. The meeting is adjourned. I thank you for your very patience.
That's next. That's the full board.